All right. Good morning, bonjour, Annie. My name is Taryn Basson. I'm the Marketing and Communications Coordinator here at the Northern Ontario Angels. We will begin this workshop by acknowledging that we are meeting virtually on Indigenous lands that has been inhabited by Indigenous peoples. We acknowledge all of the treaties and traditional territories on which all of you gathered today. So thank you so much for joining us this morning for our intellectual property branding and IP funding workshop. The Investor Ready program is an entrepreneurial training program designed to equip participants with the skills, knowledge, and tools required to create compelling business propositions and attract potential investors. So this program is a joint effort between Link North and the Northern Ontario Angels. So I'm going to go ahead and introduce Ian Lane, Executive Director of the Northern Ontario Angels.
Thanks, Taryn, and thanks for everyone for logging on today. I'm really excited to learn from our good friends at Bearskin and Parr and Northern Ontario Angels. We're the angel network here in the north in 8 chapter communities across the region, Timmins being one of them. And so always happy to work with our good friends at Link North to create some programming to help entrepreneurs and move along the development continuum and become investor ready. So just also want to highlight that tonight I'm based in Sudbury, Kim is in Sudbury, Taryn's in Timmins, but our friends at Bearskin and Parr are up in Sudbury as well too. There's an Innovation for Greater Sudbury event happening at Laurentian University this evening. So if anyone's in Sudbury, I recommend going to that. You'll hear from Noel Courage and a new founder that's based out of Sudbury called Luke Bagley, but from Circuit IQ. These are some of the programs that we do across the region. Just one happens to be in Sudbury tonight, but this Investor Ready program that we've been doing with Link North has been a fun one to watch. It's our second annual one that we've done together, and yeah, really looking forward to hearing some of the stories that come through this program. So thanks, everyone.
Sorry, I'm on mute there. Thanks, Ian. Tony, if you could go to the next slide, please. Thank you. So now I'm going to introduce Ross McDonald, Business Development Specialist at Link North.
Thanks, Darren. So welcome everyone to the start of our 2-part workshop series on intellectual property for the Investor Ready program. Before we get started, just a little information about Link North. So Link North provides business advisory services, funding, and delivers programming like Investor Ready to support entrepreneurs during all stages of business development and innovation. So this includes commercialization and scaling and growing their operations. When we first meet with clients, our goal is to gain understanding of your business, the product or technology that you're looking at developing, what your needs are, and then we work towards creating a roadmap that aligns with your vision and helps you achieve your business goals. I do want to mention again that as participants in our Investor Ready program, you can access Link North's free business advisory services to assist you with your business development. I'll just drop my contact information and a little bit of information on Link North and how to become a client in the chat box. Thanks.
Thanks, Ross. If we can go to the next slide. Now I'll introduce our experts for today, Tony Orsi and Megan Dillon. They are both partners at Bearskin and Parr. So Tony Orsi is a partner, a patent agent at Bearskin and Parr. His practice focuses on patents with an emphasis on electrical, biomedical, software, and clean tech innovations, as well as patent drafting, evaluating new technologies, and IP management strategies. Tony has worked on patent matters with small, mid, and large-size corporations, universities, and tech transfer organizations, as well as individual inventors across Canada. He's also worked with clients to develop in-house IP programs. And Megan, she's also a partner, lawyer, and registered trademark agent at Bearskin and Parr. Her practice focuses on all aspects of brand protection. Her trademark practice includes providing opinions and advice on registrability, filing and prosecuting applications, representing clients before the trademarks opposition board in opposition and expungement proceedings, and assisting clients with the management of their domestic and international trademark portfolios. So welcome, Tony and Megan. I do want to mention their colleague, as Ian had mentioned as well, Noelle Courage, who is a partner and patent agent at Bearskin and Parr. She's hosting a networking event at Laurentian University in Sudbury tonight for startups and others interested in IP and IP funding. The event's called Innovation for a Greater Sudbury IP 101. She'll also be joined by Meredith Armstrong, Director of Economic Development for the City of Greater Sudbury, and as Ian mentioned, Luke Begley, CEO and co-founder of Circuit IQ. So I will be putting a registration to that event as well in the chat box. And if you haven't already done so, please mute yourself to avoid interference. And this presentation will be recorded and it will be available after the call. All right, Tony, I'll go off and hand it over to you.
Great, thanks so much, Taryn. So just as a preliminary matter, what kind of lawyers would we be if we didn't start off with a disclaimer? So this presentation is just for informational purposes, doesn't constitute legal advice, but if you do have specific questions going forward, Tony and I would be happy to set up a call with you. Tony, next slide, please. So for the purposes of today's talk, we're just going to use a hypothetical business. So this is a business in Sudbury, a brewery by the name of Hops To It. They offer brewery and restaurant services in Sudbury, but they also sell beer and clothing, and those are wider spread than just the Sudbury area. Of course, the main market is Canada, but they're also looking to expand into the United States and Europe in the future. So moving on to the next slide, just to give you some background, there are different types of IP protection. So you have trademarks that protect brands, copyright protects creations, and industrial designs, trade secrets, and patents. And those protect inventions, know-how, and business data, and that type of thing. So moving on to the next slide, let's start with trademarks. So what is a trademark? A trademark indicates to the public that the goods and services covered by that mark come from a particular source, a particular trader. It distinguishes those goods or services from the goods and services of other traders. So really what it is an indicator of source. And there are different types of trademarks. So you have standard character marks or word marks like Coffee Crisp and Molson Canadian. There are slogans like "You've always got time for Tim Hortons" or "Swiss Chalet, always so good for so little." Then you have design marks like the Nike swoosh, the McDonald's Golden Arches, Petro-Canada, and looking at our example, you might, for Hops To It Brewery, you might have a bunny holding a mug of beer, something to that effect. Next slide, Tony. So there are also modes of packaging. So three-dimensional shapes like triangular packaging of the Toblerone bar that I'm sure we're all familiar with. Or if Hops To It were to come up with a particularly novel bottle design, so think like the Coca-Cola traditional bottle shape, then it might be possible to protect that as a three-dimensional trademark. Major amendments to the Trademarks Act have added a whole slew of different kinds of non-traditional trademarks. There are sound marks, holograms, scents, tastes, textures, all sorts of things like that. So sound marks have been around actually for a while, since 2015, and a good example of that would be the MGM Lion's Roar, the one you hear at the beginning of all MGM movies. So next slide, Tony. So if you're just in the beginning stages of choosing a trademark for your business, there are a couple of tips to keep in mind. Not all trademarks are created equal. The strongest marks, the ones that are going to give you the broadest scope of protection, are marks that are coined terms. They're fanciful or made up. They don't describe or suggest an association with the goods and services at all. So an example would be Xerox, which was a coined term it's short for xerography, and it was coined by a Xerox employee in the early 1900s. Then you go on to ordinary dictionary words that have nothing to do with the goods and services that they cover. So an example would be Apple for computers, Jaguar for cars, and Gap for clothing. So while they are ordinary dictionary words, they still have a fairly broad scope of protection because they're not connected with the goods and services that they're registered for. Then you have marks that are suggestive of, but they don't clearly describe the goods and services. So Microsoft would be an example where both micro and soft are suggestive of computer software, but they don't clearly describe that the goods are computer software. Hops to it would be another example of this type of mark, because hops, of course, is used for making beer brewery, but it's also a playful turn of phrase on hop to it. So not clearly descriptive of the goods and services. Then you get into the realm of marks that aren't registrable unless you can show that they become distinctive of your business and your business alone through extensive use in advertising across Canada. So an example of that would be Sharp for computer monitors and TV screens. So next slide. So before investing too much in our Hops to It mark, developing the logo to go with it, paying for signage and labels and advertising featuring the mark, you need to do some due diligence. And you can do this by arranging for an agent to conduct a certain level of searching. So there are different levels. You have the preliminary knockout search, where you're essentially just looking for the identical mark on the Canadian Trademarks Register. Then you have a register search, and that's a more comprehensive search of the Canadian Trademarks Register. So you're looking for marks that are confusingly similar to, that sound like, that contain similar elements to the mark that you're interested. And sort of the highest level of searching that you have is a full search. And that includes a comprehensive search of the Trademarks Register, but it also includes searches of common law databases like telephone directories, trade directories, the internet, and certain domain name registers. So the goal of searching is to determine whether your mark is available for use and potentially also for registration with the goods and services that you're interested in. So in a case where not only are you going to feature the mark on labels and packaging for your product, but it's also going to be the trade name or the trademark for the business itself, like in our Sudbury Brewery case, the Hops to It case, a full search would be highly recommended. And Tony, next slide, please. So you're going to want to know not only whether there are registered or pending trademarks on the register that are identical or confusingly similar to your mark, but also whether there are marks in the marketplace that might impact your ability to use or register the mark. And that's what a full search is going to give you. So next slide, please. Some other issues that a full trademark search will give you a good sense of is other reasons why your mark might not be registrable. So we've already touched on when a mark is clearly descriptive, but other types of marks that wouldn't be registrable are those that are considered to be primarily functional, like the shape of the Lego brick, names or surnames like Carl Jurak. Or if your mark is the name of the applied for goods or services in any language, then it wouldn't be registrable. Also, if your mark isn't inherently distinctive, and this is somewhat of a catch-all for unregistrable marks. It's a relatively new ground of examination. But anyway, if you have a situation like that, the only way that your mark would be registrable is if you can show through affidavit evidence that your mark was distinctive as of the Canadian application filing date through extensive use in advertising across Canada. Next slide. So then you get into strictly legal or legislative-based issues. For instance, there's a special breed of mark owned by governmental agencies known as prohibited or official marks. And you can't register or use a mark that's identical to one of these marks, or that is so similar to is likely to be confusing with one of these marks. And you can't adopt geographical indications like Bordeaux for wine that doesn't come from the Bordeaux region of France. So in any event, searching can be helpful in terms of identifying these issues up front. So you can either choose a different mark, or at least you'll know the types of obstacles or difficulties that you're going to face with that particular mark. Next slide, please. So once you've settled on a mark and you find that it's available for registration, you can file an application with the Trademarks Branch of the Canadian Intellectual Property Office, or CIPO. The application will be examined by an examiner at CIPO to make sure that it complies with all of the technical requirements under the Act and that it's registerable. The examination process is currently taking more than 4.5 years. So keep in mind that, that the application process takes some time. Start early. There are strategies to cut that time down, and we'd be happy to discuss those with you if you are interested in filing a trademark application. So assuming that the examiner doesn't identify any issues with the application, it'll be approved for publication, and then it's going to be advertised for opposition in the Trademarks Journal. And this just gives interested third parties the opportunity to oppose the application if they have some reason to object to it, whether they have their own confusingly similar mark, or whether they feel that the mark shouldn't have been considered registrable in the first place. This is their opportunity. But if no opposition is filed, or if an opposition is successfully overcome, then the application will issue to registration for a term of 10 years. And that 10-year term is renewable for further 10-year terms, potentially indefinitely. Now, the decision as to whether to file an application is going to depend on a number of different things. So there are certain cases where it might not be worth it to file. For instance, if the mark is only intended for use on a short-term basis, say in a seasonal advertising campaign or something like that, by the time you get the registration, your campaign will be over, so it'll be a moot point. As I mentioned, you don't have to register a trademark in Canada in order to obtain rights in it. You obtain rights through use in the geographical area where you're using the mark or where you have a reputation in it. And those are known as common law trademark rights or unregistered rights. So say there was a Hops To It business in Victoria, BC, they could potentially prevent our Sudbury Hops To It brewery from selling their beer in Victoria, but they can't stop Hops To It from opening in Sudbury under the Hops To It name, because they wouldn't have a reputation there. But with a registration, you have rights across the country. So if this Victoria Hops To It had a registration, then they could potentially stop our Sudbury business from opening under Hops To It in Sudbury, even though they only have use in Victoria. Also, the owner of a registered trademark can sue for trademark infringement and for depreciation of goodwill, whereas if you only have unregistered rights in a mark, you can only sue for passing off, which is much more difficult to make out, and it can sometimes be a more costly process. There's also a psychological benefit to registration as well, because it's its own form of policing. Because if a third party was thinking of adopting a confusingly similar mark, if they conduct a search and they find that there's already your mark on the register, then they might think twice about adopting that mark. Finally, if you're going to be carrying on business in Quebec, there is, under the Charter of the Charter and l'Office de la Langue Française, if you do not have a registered trademark, you're often required to translate your trademark on packaging and signage, etc. So in that sense, it can also be beneficial to have a registration. Next slide, please, Tony. So in developing your trademark strategy, you're going to want to consider certain factors, and these factors are not only for your business edification, but they're also things that investors are going to want to know that you've done and you've taken into consideration. So as I mentioned, when you want to choose a distinctive trademark and avoid suggestive or descriptive marks, because you want a strong mark in order to differentiate your goods and services from those of others, and also to give you the strength in the mark to enforce it. because if you have a mark that's weak and that, is in common parlance or it's somewhat generic, then you're not going to be able to stop third parties from adopting confusingly similar marks. Also, once you've settled on a mark, as I mentioned, you're going to want to do some due diligence, so some searching. And investors are going to want to know that you did this so that they know they're going to be able to avoid, sinking money into a brand that might get challenged down the road. You want to consider whether or not to file for the mark. And if you are going to file for the mark, then you want to file not just for the goods and services that you're using the mark for now, but think ahead. Think of what you might want to use the mark for in the future, because you can file more broadly in Canada where use is no longer a prerequisite to registration. You also want to let others know that you're claiming trademark rights in your trademark, and you can do this by marking the trademark with a TM symbol, and you can use the TM symbol regardless of whether the mark is registered or not, or you could mark it with the R in the circle, but only if it's registered. And this just puts people on notice that this is a trademark, and so they should not be adopting this themselves. Also, if you think your business might expand beyond Canada, for instance, in the Hops To It case, there's interest in the US market and the EU market, then you want to do searching in those countries, and you want to consider how to protect your mark in those countries. And there are various different ways to do it. You can file domestic applications in each of the countries of interest, or you could consider regional protection. For instance, the EU trademark system covers all of the countries of the EU, or there is something known as an international registration, where you file a single application with the World Intellectual Property Organization, and you can designate any number of different countries under that single application. So there are, of course, pros and cons associated with each different filing strategy, and you would want to discuss that with an agent before proceeding. Finally, once you have an established brand, maybe even a trademark registration, that's not the end of the process. You really need to police your mark. So if you see someone out there in the marketplace adopting a confusingly similar mark, you need to go after them. You need to send demand letters. You just need to make sure that you police that brand, because if you don't, it loses its strength and its value. So I guess basically what I want to leave you with is that always remember your trademarks are a business asset, and they need to be protected just like all of your other business assets. So Tony, I'll pass it on to you now.
Okay, thanks very much, Megan. All right, so moving along here, we're going to talk next about trade secrets and patents and a few other related items as well. So trade secrets are a form of protection. Basically, this would be used to protect confidential information that has value to the company, and you would need to take steps to maintain that information in confidence. And so that would come down to, putting contractual means in place. So if you have NDAs or other agreements with third parties, or even agreements with your employees and co-founder agreements, you want to make sure that there's clauses in there that would specify that the confidential information would be kept in secret, and maybe what the other party can do with that information. And the other part of this as well would be maybe putting in other security measures as well. So you could use password protection and limit access to certain areas or computers where this confidential information may be. In terms of strategy, if you're looking at trade secret protection versus patent protection, there does come a fork in the road, so to speak, where you do need to pick one versus the other if you are interested in patent protection. With patents, you do need to describe how the invention works, and that does get published eventually, even if you do not get patent protection. But even if you are interested in patent protection, everything would start off as a trade secret. Basically, the patent system would require that you you maintain the invention as a secret until you file the first application, although some countries do give grace periods for public disclosures. But even then, from a business perspective, you want to be careful in terms of when information about what you're doing makes it out into the marketplace. So, in terms of strategy, then, there would come a point in time where you may have to decide between, maintaining trade secret protection or, going the patent route. And when you're making that decision as well, you'd want to look at the pros and cons for each of these things. So with respect to trade secrets, for example, if you're able to maintain that secret for a longer period of time than you would if you were able to get patent protection, for example, then that could be used to extend the length of time that you're maintaining your competitive advantage. The risks, though, of course, are whether anyone is able to independently come up with that trade secret, or if the confidential information makes it out into the public domain, either on purpose or by accident. So those are some of the things that you need to consider, and it'll come down to the the nature of the information as well. So if it relates to a product that will make it out into the marketplace where somebody could purchase it and reverse engineer it, then that wouldn't make a good candidate for trade secret protection. But if it's something that maybe is housed internally, if it's maybe a processing line, for example, or it could relate to maybe something that's happening with software and it's being hosted on a server that's on the back end, and it's very difficult for others to come up with what you've innovated on, then it may make more sense. For patents, on the other hand, they are a bit more tangible in the sense that you could sort of point towards what you have protection on, and you are able to define what is being protected through the claims of the patent, basically, which are used to protect the innovative aspects, which are unique compared to what's been done previously. And this could be important in terms of perhaps raising investments. So depending on the technology, some investors may want to see that there's some patent filings in place to reduce their risk. It may also be used to attract partners, for example, in terms of showing that you've got some know-how and ingenuity in a particular area that others may be interested in and may want to partner with you to further develop the technology, or perhaps even license the rights to the technology. And then also in terms of some government applications, filing a patent application may be a requirement of them. So it could also help in terms of getting some funding that way as well. So, yeah, as I had mentioned then, in terms of the trade secret protection, it could basically be used, for as long as that information is still valuable and it is kept secret. So it could, definitely be applicable in some situations. One of the areas which is becoming more popular these days is data. So basically, the gathering of data, which could then be mined for, certain purposes. Certainly in the case of, artificial intelligence, where, you need training data to be able to train the AI and sort of maintain it and continually update it and improve its performance. Data is key there, and you could perhaps use trade secrets, and as well as making sure it's clear who owns that data. And then you can even look at maybe trying to monetize it as well. So letting others have certain types of access to be able to perhaps mine that data for certain purposes. Now, in terms of patent protection, there are two different types of patents that could be pursued. So one of them is industrial design patents, and the other we refer to as utility patents, which are the more sort of well-known patents. So we'll talk a bit about the design patents for now. And these types of patents are used purely to protect the appearance of a good. So basically the design in terms of some, an ornamental or visual design would be protected through this type of patent. And it could be applied to something which is more physical in nature, so furniture or clothing or vehicles, or it could also be applied to things which are more graphical in nature, or virtual, so to speak. So it could apply to graphical user interfaces and perhaps some icons as well. If you're interested in this type of protection, the design has to be kept secret until you file your first application on it. You would basically file on a country by country basis. And so looking at the countries where you would have the largest market opportunities and the largest return on investment, defining those, and then selecting from them based on what your budget is to pursue protection in those countries. So you do have to put together an application for this, and basically it mainly consists of drawings which show the designs. You could have variations on the designs and include them in one application. And also, to try to make your protection broader, you only want to show the essential aspects of that design, which you would want others to not copy in solid lines, and other things which could be optional or could be changed in different variations of the design, could be shown in dashed lines. If you are able to secure protection, then it's the term is 10 years from the registration date or 15 years from the filing date, whichever is longer. And if you are interested in this sort of protection, you would want to consider it closer to the final stages of design, before releasing a product to the marketplace, just because you can go through many iterations and customer validation cycles. And so you want to make sure that when you file an application like this, you're capturing your go-to-market product. So this slide here shows some actual registrations, and sort of keeping along the theme of our example in terms of Hop To It Brewery. Here's a couple of examples of some registrations for one is a beer bottle on the far left, and another is a beer keg on the far right. And in terms of something which is a bit more virtual in nature, there's an example of a registration for a graphical user interface for a medical imaging software. And yeah, this example speaks to the point that I made earlier, where the things which are part of the design are shown in solid lines, and then the things which are optional or could vary are shown in dashed lines. And so you could use this software program to view different types of images, and so you wouldn't want the image to be part of what you're protecting, and so that's shown in dashed lines there. So moving on to utility patents now. These types of patents are used to protect the structure and or functionality of an invention, and these are powerful rights in the sense that others cannot plead ignorance if they didn't know about this patent and they were infringing on the the claims of the patent. And they also have a limited amount of time. So the time period would be 20 years from the filing date. In some cases, it could be extended in certain countries under certain situations. And again, just like with the design patents, you would be filing on a country by country basis. Some regions could be grouped together. So, there could be, if you're interested in several European countries, you could go and file a European patent. Same thing with the design as well, European design. Or you could do a mix of that. So it could be a regional patent like Europe, and then you may want North American protection, in which case you'd file separately in the US and Canada. The same sort of rule applies here in terms of keeping the invention secret until you file your first application. But some countries do give grace periods if there's been public disclosures. And that would include Canada and the US. They each give a 1-year grace period. And in terms of what's meant by a public disclosure, really that's any sort of dissemination of information about the invention to the public that's not confidential. And the information would be enough such that somebody skilled in the art would be able to figure out the unique aspects of the invention that you're claiming. So you want to be careful, when you're engaging with others, that you may need to tell them about the invention, and it could be a manufacturer, for example, or an R&D partner, or others, and make sure that you have an NDA in place. If you're, maybe doing a pitch competition or putting information online as well, you need to be very careful about timelines. And so with the patent process, it's very timeline oriented, and, to make sure that things are done properly, you want to plan for these, for this, and, make sure that ahead of time the dates where you may be engaging with the public, doing like a product launch, for example. And, if you do want to get patent protection, making sure that you get that done ahead of time. In terms of the application itself, here it would be a combination of text and figures, really being used to describe how the invention is structured and functions. And again, if you want to have broader protection, you want to try to describe different variations on the invention. So you just don't want to think about the preferred way of doing it. But if there are other ways of implementing it, even though they may not work the best, you would still want to cover those off, and you'd want to try to think like a competitor. How could a competitor design around what you want to get protection for, and then try to cover off those design arounds in your patent application. In terms of what's protected, so this comes down again to what I mentioned before, the claims, these sentences at the end of the patent that describe the unique elements and how they come, how they work together to basically enable the invention. And you want to try to I guess structure these things so that they're broad, but they cannot be overly broad such that they cover what's been done previously. So there's a balance there, and you'd only be able to get protection for what's unique. So in terms of deciding whether it's worthwhile to proceed with patent protection, you always want to be thinking about the business value and the business strategy and what the benefits would be there in terms of proceeding with patent protection. And just as Megan had described previously with trademarks, and considering what they would be used for and whether the timelines align, you want to consider the same thing with patents as well. So if there's an invention that's going to be sold as part of a product only for the next 2 or 3 years, then it probably wouldn't make sense to go forward with patent protection, because it could take 2 or 3 years or even longer to get the patent actually issued. But if it's covering something which is part of that product that you're going to sell for the next 2 or 3 years, but then also part of future versions or alternative products that would be sold after that, then the timeline starts to align and make more sense. You also want to try to get a sense of what sort of value the protection would provide. And so basically looking at what it is that you'd be able to protect and how that may translate into the actual return on investment when you're commercializing and selling products or services based on the invention. The other thing too is, you want to look at the amount of protection that you would be able to obtain for this. And, as I mentioned before, the claims which define that have to be unique compared to what's been done previously. So, the more crowded a field is, the more things that are out in the public domain that could be related to your invention. This may cause your invention to be, in terms of the protection, to be narrower in scope, because by definition, again, you have to claim something which is unique. So if the amount of protection is too narrow, such that it would make it easier for a competitor to design around your claims, then that probably wouldn't make sense for patent protection either. However, in some cases, even if you are covering something which is more narrow, if it's something which is absolutely needed for commercialization, then it could make sense in that situation. So just like anything else in law, it really depends on the situation at hand in terms of determining whether or not to proceed. If you are interested in proceeding with patent protection, you've decided or determined that there is a good business value for going forward with it. You then want to look at the patentability criteria to make sure that they're all satisfied for the invention. And I've listed them here on the slide. So basically, with patentable subject matter, it really relates to the nature of the invention itself and whether a patent office would grant protection for that. So you would be looking at, what sort of thing the invention is. So is it a product, an actual consumer product, or is it a machine for performing some operation, or maybe a processing line for producing a product? Those would be things which would satisfy this criteria. But if it were things such as just a concept, so it's not implemented at all, or if it's purely A theory, like a mathematical theory, for example, or a law of nature, and it doesn't have any sort of physical application, you wouldn't be able to patent those. So really it's coming down to protecting the implementations, and they have to have some sort of practical application. And here the caveat is with software. Software, is scrutinized more heavily for this criteria, and you really need to look to see what the software is doing from a technical perspective, what sort of challenges are being overcome, and what is the engagement, so to speak, between the software and the physical world. So those are some things that would need to be looked at further if it was a software-based invention. Another criteria is novelty. So basically, once you identify what you think is unique, you would then do a prior art search. So prior art is anything in the public domain that is, predates your invention. Basically, the filing date for your patent application is used as the yardstick here. And you would look to see if there's any reference anywhere in the world, and it can come in any form. So it doesn't have to just be a patent or a published patent application. It could be a technical article, a web page, a video of a presentation or a demonstration, anything that could relate to the invention. If it describes everything which is in what you want to claim, what you want to protect, then your invention wouldn't be new. So, it's important to go through and do that assessment. Now, again, you wouldn't be able to look everywhere in the world. And so when you're doing this sort of assessment, you could never get 100% yes or no answer. But, the idea is to do as much as you can in terms of the searching and look in places where you're more likely to find similar things to be able to get useful information to make a business decision on this. Another criteria is utility. So the invention has to work. You have to provide enough of a description so that somebody skilled in the art, when they read the application, can practice the invention. That's basically a requirement that the Patent Office places on the applicants. And then finally, another criteria is inventiveness or non-obviousness. So this again relates back to the elements that you think are unique, and you would need to do a prior art search. Again, it won't give you a perfect answer, but here basically you're looking to see whether there's any combination of references, of prior references, which together, if you were to combine them, would describe your invention. And part of the assessment here is whether it would be obvious to somebody who has average skill in the field to make that combination and sort of make that, sort of make that determination. And there's lots of things that you can look at here to try to determine whether, you sort of met this criteria, and it could be through looking at, advantages that your invention has compared to other competing products, or you could be looking at, if you're solving a problem that's not been solved before, or your solution is more robust, or there's some sort of aspect of it which provides an advantage that others do not have. And and also, if it's something that took a while to to work on and get to work, those could all be indicators that you've met that criteria. So to be able to, to do this assessment with respect to novelty and non-obviousness, you'd want to do this prior art searching. And part of it could be, through patent searching. There's various databases that are available online and tools that you could use to do this searching. And I've listed some of them on the right-hand side there. But basically, when you're doing the searching and looking at it from the patentability perspective, you basically want to see, whether you've got something which hasn't really been described before. There's another way to do the searching as well, and this is from the perspective of freedom to operate. So it's sort of the flip side. So with patentability, you want to see whether you can get patent protection for what you've developed and prevent others from doing what you're able to get protection for. But from a freedom to operate perspective, you're looking to see whether others have patents with protection which is broad enough to cover what you want to commercialize. And so in a country, of course, where you want to commercialize, and that patent has to be still active in that country. So if you're innovating, let's say, on someone else's invention, this may become more relevant in terms of having to check on this. And a way to think about this is just to look at a pretty simple example where let's assume that a company A has invented the stool, basically consisting of a seat with 3 or 4 legs, and they get a patent on that. And then company B is using the stool, and they realize, well, my back gets tired, and so they come up with the idea of putting a backrest onto the stool, so essentially creating a chair. So assuming that no one, that's inventive, they may be able to get a patent for that. But if they then want to start making chairs in a country where company A has protection on the stool, and their chair consists of a seat, with 3 or 4 legs, then they would potentially be blocked by company A. So they would either try to license the rights from company A to be able to make their chair, or they could try to design around company A's patent. And so instead of having legs for the base, maybe there's some other type of base which is used for the chair. So that's sort of how that works in terms of being able to get patent protection, but then also being careful about freedom to operate as well. So in terms of patent filing strategy, just very quickly, there's different types of applications that could be filed, and they really depend on the stage that the invention is at, and what the commercialization strategy is. If the invention is pretty much fully worked out, but there's still some innovation that might be done, but you have, say, like a first version that's working and has unique aspects which are valuable, you could look at doing a US provisional, which then provides you with the ability to add to it later on when you do the full filing. When you do the full filing, you won't be able to add any more details to the description. So you need to make sure that you're ready at that time to file such an application. And again, as I mentioned before, you want to try to describe lots of variations in implementation, and also think about different use case scenarios. So not just looking at how it's being used today and in the near future, but trying to look out further than that to see how it might be used in other industries, for example, or for other things, and trying to include that in. Just as Megan had mentioned for trademarks, from an international standpoint, there is also an international patent application. However, it's important to realize that this never issues into an international patent. Rather, it's a type of patent application that's filed, which provides more time before you actually have to file on a national basis. They also do some searching and give some information on patentability as well. So this, could be a potentially useful application to file, where you may need more time for determining, how successful the invention is, and perhaps, getting partners on board, or raising further funding to support this international patent strategy. And in terms of the countries where you want to be looking at filing, you want to look at, the markets where you would get the largest ROI. And if you have, a large enough budget to support it, looking at other countries where maybe your partners or competitors might be interested, and where your manufacturers might be interested. But when it comes to your patent filing strategy, you want to take a holistic view. In fact, for your entire IP filing strategy, or implementation strategy, to make sure you have enough funds to cover everything that you want to do. And from a patent perspective, it may be more important to file patents for different inventions, rather than file patents for the same invention but in more countries. So again, it comes down to your portfolio strategy and what's more important there in terms of the amount of protection that you want to have in place, and what your budget is like. Another thing which is really important to think about for patents is that there's a difference between inventorship and ownership. So inventors would be those who are making creative contributions to the essential elements of the claims. So it's not, I guess, a situation that you may find in, say, academic circles, where when an article is published, you might include an author out of, sign of respect, for example. Here, the inventors really have to be people who actually made contributions to what's unique about the invention and what's claimed. If there's somebody who's just doing testing and they just provide test results, they wouldn't be an inventor. But if they do the testing, look at the test results, and then figure out ways to improve the invention, and those improvements are in the claims, then they would be an inventor. From an ownership perspective, if there aren't any other agreements in place or obligations, the inventors would be the owners. But typically, inventors are employees, or they're part of some, maybe an academic institution, and there could be policies in place and agreements that they've signed whereby, anything that they create during the course of their employment would actually be owned by the entity that they work for, or maybe they're acting as contractors. And again, even though they're developing this technology and becoming inventors, as part of the agreement, they may have agreed to assign their rights to the company who they're doing the contract work for. So for all of those people out there that are running your own businesses, from your perspective, you want to make sure that you have agreements in place so that the ownership would clearly reside with your company, and making sure that others would sign these agreements, agreeing to that assignment of ownership before they do any sort of work or make any kind of suggestions that could lead to an invention. Now, just really quickly, some considerations for startups and SMEs as you're growing. Of course, from a patent perspective, you want to be filing on core technology, making sure that there's value in your filings, and always considering the business case for this, and being very selective. So at the beginning, your budgets are more limited, and you want to be very selective on what you do protect and the countries that you do protect in. And then as you start to grow and you have more of a budget and your technology evolves, you can start to think about filing for protection for some of the innovations or expansions on your technology, and maybe looking at some additional countries that you want to protect in. And then certainly all the way throughout, whether you're a startup or an SME, you always want to be thinking about using patent publications or issued patents as a source of competitive intelligence. So you could use this to see who the competitors are in the field, and consider freedom to operate as well. And if there are some issues, dealing with them sooner rather than later, in terms of making sure that you don't get into any trouble when you do commercialize. So going back to our Hops To It brewery example, so what could be done to protect some of the unique things that they do? So some things that could be unique that they're working on, maybe or that they've done, could be the ingredients. So perhaps the particular ingredients that they're using as they're brewing their beer, or some specific formulation, I guess, for lack of a better word, in terms of the amount of ingredients relative to one another, but also maybe even the brewing process too. So there could be something there where maybe they've developed some equipment that allows them to brew their beer more efficiently. So in either case, patents could definitely be an option if these things that they've done are truly unique compared to what's been done before. Trade secrets might be an option as well, and certainly that is used, in some cases for consumer, products, or foods or beverages, where there's some sort of unique thing happening that's hard for others to come up with themselves. That Coca-Cola is the best example there of that. And we also mentioned that they create products too, so it could be beer bottles, and so if those have a very unique appearance, you can look at design patent protection for that, for example. And in all of these things, you want to be thinking about the main markets and what your country filing strategy would be as well, and obviously considering your budget too. So just a few other slides here before we finish off. The slide here is dealing with some tips when considering IP and pitching investors, or even if you're just taking part in pitch competitions. So starting with pitch competitions, as we had mentioned before, for patents, it's very important to make sure you don't have public disclosures before you file your patent applications. And even then, if you filed your applications, you still want to be very selective in terms of what information you share with the public. So if you're doing a pitch competition and you need to talk about, what you've developed, you want to treat it as a black box. So you definitely don't want to get into specifics about any particular implementations, and you may talk about it more in terms of problems that are solved, or maybe some characteristics of it, for example, or maybe even comparing it to some other products in terms of what you can do and those can't do. But again, just be very careful that you're not tipping your hat to anything that you want to protect. From an investor perspective, if you're pitching investors, again, you don't have to get into details. A lot of times investors won't sign NDAs, and so you'd want to keep these presentations more high level. And you could maybe discuss some of the existing IP that you have, again, keeping it high level. You can look at the technology and maybe, also not maybe, but also considering the branding as well too, because that could be very important. If you have trade secrets, of course, you don't want to disclose those, but you may say that that could be part of your IP strategy in terms of protecting what you've developed. You may also talk generally about future IP, but again, keep it extremely high level. Don't get into details. You don't have to provide any sort of registration numbers for patents or trademarks either. But so basically being careful what you share, and keeping it high level as well for investors, but being ready though, in terms of if they do ask questions about IP, if you've done any searching, if you have an IP strategy in place, so that you are able to talk about it at some higher level. Now, hopefully if you've, gotten their attention and they're interested and they want to do a deeper dive, then you want to be sure that you're ready for IP due diligence. And so basically, always making sure that you've got your IP documented and making sure that, you've currently got, you've got the owners and inventors listed properly, making sure that that's all tidied up. You've got the agreements in place that you need to show ownership and control. If you're using open source, you want to be careful about making sure that you're not opening yourself up to any sort of obligations with open source software that have more restrictive license agreements. And then you want to be able to discuss the strength of your portfolio, and talk about the plans that you have in place, and what your IP strategy is as a whole. And now just last slide here before we finish things off and open up to questions. There are some IP funding programs which are great for startups and other organizations as well. These have been coming online recently, in the past year, and there's different types of programs as well. So I won't go through them in a lot of detail, but I've listed them here in the slides with some links, and you should all have copies of the presentation and we'll be able to look into these. But there's the IP Assist, which is through NRC, and it could also be provided through some other organizations as well. And it allows for, providing IP education to the startups, and also helping them to work on certain aspects of their IP strategy and certain types of IP action items. There's Elevate IP, which is a national program, and this is facilitated through different organizations across Canada. So depending on where you're located, you'd want to consult with your local regional innovation center, as they may be one of the vehicles through which this program is delivered. And again, it covers IP education and strategy, but there's more things that could be covered in terms of IP action items. So, it's a very good program to look into. There's also provincial programs. And so in Ontario, there's IP Ontario. And again, they've, just fully launched, I think last week. And so definitely go to their website. They cover off certain technology areas and, can provide, I guess, up to about 25,000 in funding in a single application. You may be able to go multiple times. And again, they have programs in place to help with IP education, and also, covering some of the IP strategy and implementation things. And then there's a couple of other government programs as well. So CanExport is more related to, companies' activities with respect to engaging with foreign partners and commercializing in foreign markets, but there could be some funding there for IP for filing in foreign markets. And then Innovative Solutions Canada has these challenges, for certain technology areas. And so if that aligns with what you're, developing, these could be good for you to look into to, again, get funding at different stages that may also cover IP. And with that, that is the presentation. So we'll open it up for questions. Taryn, I'll turn it over to you.
Thanks, Tony. Looks like we do have one question in the chat here. Dean is asking, how can a startup hope to establish a market presence that is protected if they have to wait this long for a trademark? So I think this is directed for Megan.
Right. So, as I said, trademarks are not just obtained through registration. Trademark rights are also obtained through use. So just because you don't have the registration doesn't mean that you can't use the mark. Start using whenever you would like to. Do the searching before you start using, because you know, you can get into hot water if there are other people using a confusingly similar mark. But once you've cleared the mark, go ahead and use it. You do not have to wait at all for that registration to issue.
Awesome, thank you. Did anybody else have any questions? Feel free to unmute yourselves or type it out in the chat. Okay, we have one here. Glory is asking, can you associate a brand's trademark to the brand owner's name?
So I'm not sure if I completely understand that question, but I think I do. So the answer is yes, you do associate the mark with the brand owner's name. So think of packaging for anything. So I'll give you an example. Mr. Christie crackers. Okay, so if you look at the trademark legend on packaging featuring the Mr. Christie trademark, and say Triscuits trademark, you're going to see that is owned by Intercontinental Great Brands. That's the entity that owns the mark. It's associated with Mondelez, which is the umbrella company that owns those marks. So yes, you do associate your mark with the brand owner, but it's not so important that people know the name of the brand owner, as that they associate the goodness of the Triscuit cracker with the Triscuit brand. So you don't want anybody to associate the goodness of that product with another brand. It's not so important that you know who owns that brand. It's just that you're going to look for Triscuit brand crackers. You're not going to look for another brand crackers.
Awesome, thank you. Any other questions?
Karen, I
While
have
we
one.
wait, oh, go ahead.
If you have a patent and it expires, what are some steps you have to do to get it back on, or can you sell it if it's expired?
So yeah, if you have an issued patent that's expired, so you've finished the patent term, you wouldn't be able to extend it, unfortunately. And if you wanted to still have some form of protection, then you would be looking at any sort of modifications or improvements that you've developed, which would still sort of, or which would meet the patentability criteria, and of course provide value, and looking to see if you could file those applications before you have other patents which are coming up on expiration.
Thanks, Tony. We do have another question from Dean. I believe this is a follow-up to the first one. He's asking, how about trade names?
So sorry, can you go back to what the question was?
Yeah, for sure. So I think he was asking about how can a startup hope to establish a market presence that is protected if they have to wait this long for a trademark. So I think he's asking if he can use trademark names as well.
So trade names and trademarks can sometimes be interchangeable, because a trade name is essentially the trademark for your business. It's what your business is known as to your customers. So same thing there. You can establish common law rights in your trade name. Also, you can register a trade name separately from a trademark. You can register it under your corporate entity as the business name under which you're conducting your business. So not only is there a separate registration process, but yes, if you're using that trade name as a trademark as well in association with the goods and services that you're offering, it's the same thing as with a trademark. You're gaining rights in that trade name as you use it and as you obtain a reputation in it. So no need to wait for the trademark registration to issue in association with that trade name.
Awesome. Thanks, Megan. I do have a question myself. In terms of marketing and content creation for people who use social media to market their small businesses, I'm currently working with a client who is trying to build awareness for each month. So each month there's a different disability awareness, and there's a certain song that's associated to each disability. So she was kind of asking me, what do I do about music licensing? Do I need a license from SOCAN? And how would she go about that?
So that's a copyright question, and my practice focuses on trademarks. So yes, there would be clearance that would need to be done. I don't know exactly what that clearance involves, but we certainly do have people here who can help with that. But yes, I would look into a SOCAN license for any type of use of that sort of a copyrighted work. So yes.
Sounds good. Awesome. Another follow-up question from Dean. Provincially in Alberta, one might go to the registry for a nuance search. And does that protect the trade name, company name in brackets for a while until incorporation?
So you can register the trade name, and the nuance search is it's not comprehensive. It's not going to stop you from registering a trade name that might be confusingly similar to another one that's out there. So I wouldn't base your clearance, your due diligence solely on a nuance search. I would also do, if you're using this trade name as a trademark, which I think is the idea here, you want trademark clearance as well as the nuance trade name clearance. So I hope that helps. It's, yes, you can register your trade name separately, but it doesn't necessarily mean that it's clear for use as a trademark. So do the full due diligence. You don't have to wait for trademark registration to use it, but just know that you're clear, you're free to use it before you start using it.
Awesome. Thanks, Megan. Did we have any other questions? Feel free to unmute yourselves. I think we're good. If we could switch to the next slide. All right. I just wanted to thank everybody for participating today in our intellectual property and branding and IP funding workshop today. Just a reminder, a link to this recording will be available after this call as well, and we will have the slideshow provided to you also. I would also like to thank our gold partners, Bearskin and Parr, for co-hosting with us today and sharing their expertise. A reminder that their event at Laurentian University is tonight at 6 p.m. and they will also be hosting free IP strategy consultations this afternoon and tomorrow in person and online if necessary. So please reach out to myself or Tony or Megan for more information on setting up one of these consultations, and we'll get you in order. And just another reminder, next week is our last workshop. It's part 2 of our intellectual property series. This time it will be with Elizabeth Collison, acting intellectual property advisor at the Canadian Intellectual Property Office, so CIPO. So this is going to be next Thursday, November 16th at 10 a.m. The same Zoom link will be used for all webinars, and you will receive a reminder for this information as well. And then last but not least, Tony, if we can switch to the next slide. Just a reminder, we are also hosting our Investor Ready Close event on November 23rd at Full Beard Brewing here in Timmins to help celebrate the end of the program. It's free to register. We'll have live music from Paul Sebald and catering from Fusion Grill. So this is a great opportunity for networking with fellow entrepreneurs. And we hope to see you there. And that's the end of my spiel. Hope everybody has a great day. Thank you so much for joining us.
Thank you very much for attending, everyone.
Thank you. Bye.
Thanks. That was excellent. Thanks very much.
Thanks, Ron.
Thank you. Bye-bye.